Good afternoon, everyone. This is Dismas Locaria with Venable, and I'm joined today by two of my colleagues, Chris Griezak and Spencer Williams. Today, we're going to be talking about the Bayh-Dole Act. Before we jump into that, just want to thank you all for coming and participating this afternoon or this morning, from wherever you might be. We are broadcasting from our homes, as I hope everybody is being careful to be socially distant and take care of themselves. So best wishes to everybody in this unusual time that we're living in. Today we're going to speak about the Bayh-Dole Act. It's a 40-year anniversary, and two of my colleagues, Chris and Spencer, will talk about the nuances of it as they've been helping me advise a number of our clients. As many of you know, Venable has a robust government contracts, but also a robust grants practice, and that often leads to counseling and assisting clients with understanding the rights and the issues underneath the Bayh-Dole Act. So with that, I'm going to turn it over to Spencer to get us started. Spencer?
Thanks, Liz. Hello, everyone. So I'm going to start with a brief overview of the history of the Bayh-Dole Act. Just want to note that this year marks the 40th year anniversary of the passage of the Bayh-Dole Act. It's actually called the Patent and Trademark Law Amendments Act, but it's more commonly known as the Bayh-Dole Act after its sponsors, Senator Birch Bayh, who's also a former Venable partner, and Senator Bob Dole. The origins of the Bayh-Dole Act go back to the 1970s. Congress was concerned with the state of the economy, and so they're trying to find ways for growth. So looking around, Congress and realized that federal agencies held about 28,000 patents, but they had a very low utilization rate. Fewer than 5% of those patents were being licensed. They also found that there were about 26 different federal agency policies regarding treatment of federally funded research and patents that arise from it. In response came the Bayh-Dole Act. Here you see its policy and objective. Mainly what Congress did here is they realized that the researchers, the grant recipients, universities, they were the one that better positioned and had the motivations in place to increase the utilization of any patents. And they did this by permitting these entities to retain ownership over inventions made under these federally funded contracts and grant agreements. So what it does is it allows for the researchers to partner with like third parties to actually bring to market products that are built off of this patented research. And in the 40 years, you've seen that it's actually done, the Bayh-Dole Act has been mostly successful when you compare it to those objectives. Based on various sources, it's bolstered economic output by over $1 trillion, supported a large number of jobs. Some commentators have noticed that like entire industries like biotech would not exist without the Bayh-Dole Act. Excuse me. And a number of companies have been spun off based off of university research patented discoveries. A good example is Google. The underlying algorithm for their search function was developed at Stanford University and licensed to what became Google and what we all know of today as Google. Other thing, it's also, you've seen at universities the expansion and creation of these technology transfer offices. These are TTOs. These are internal divisions that are responsible for managing the university's IP rights. And with that, I'd like to turn it over to my colleague, Chris, who will give you more information about the mechanics of the Act.
Hello, everyone. This is Chris Griezak. Thanks for the introduction, Spencer and Diz. So I'm going to talk about first the basic mechanics of the Bayh-Dole Act, how it works, what Congress set up in terms of its structure, and then I'm going to cover how entities that are trying to protect their interests in subject inventions under the Act can do so. So first, in terms of relevant authorities to consult, obviously the statute itself, I have it cited here on this slide, as well as the implementing regulations, which are at 37 CFR 401. And I also want to note, though, that you really need to check your grant terms and conditions. The primary way that the Bayh-Dole Act is implemented is by the insertion of a standard clause, which is included in those regulations, into the funding agreement itself. And that clause outlines the various rights and obligations that you have and need to follow. And importantly, as we'll discuss here in a few minutes, those rights and obligations can be modified or altered before going into the agreement. And so it's really important that you not just rely on the regulations in the statute itself, but you actually look at what is in the agreement. I also cited here the government guidance. One example would be the Department of Commerce's Grants and Cooperative Agreements Manual, which includes some guidance on the Bayh-Dole Act, but obviously your funding agency might have other guidance that could be relevant to how they interpret the standard clause that's in your contract. So the general rule under the uniform guidance for grant recipients is that title to intangible property, which would include patents and inventions, is acquired under a federal award such that it vests upon that acquisition in the non-federal entity, in the grant recipient. And the Bayh-Dole Act creates what I'm calling a quasi-exception to that. You still get title to the subject invention, but the government shares property rights in that invention as well. So it becomes very important to know what inventions are subject to the Bayh-Dole Act and its requirements and what inventions are not. And the key test is whether or not the invention was conceived or first actually reduced to practice in the performance of work under a funding agreement. So the Bayh-Dole Act does not generally apply to inventions other than those that meet this definition of a subject invention. So an invention that's made outside of your research activities that you're doing for a government-funded project would not be subject to the requirements that we're talking about today. And then I also include on this slide the definition of a funding agreement. It's basically any contract, grant, or cooperative agreement. When the Bayh-Dole Act was first passed, it was really about nonprofits and universities. Now that's been extended to any contract, grant, or cooperative agreement with the federal agency that is for research, whether it be experimental, developmental, that's funded by the federal government. So let's dig into those rights a little bit, those shared rights and subject inventions. The non-federal entity's right, whether you're a grant recipient or a contractor, is the entire rights, title, and interest throughout the world to each subject invention. And that sounds very broad, but the key point that I put on this slide is that these rights are limited in some important ways, and they can actually be lost without due diligence, which we'll discuss later. The government's right, rather than being titled, as I said before, is just a license to practice or have practiced on its behalf the subject's invention throughout the world. And while this sounds limited, there are some key things to know about it. In particular, grant recipients have specified obligations that you have to make sure you do and meet to help protect this license for the government. And that's what we're going to talk about on this next slide. So the first and the most important one, that's why it's in bold and red there at the top, is that you have to disclose each subject invention to the federal agency within 2 months after the inventor discloses it in writing to non-federal entity personnel responsible for patent matters. And we'll talk about this a little bit more, but if you fail to make that disclosure, you can actually lose your title and even a license in the invention that you made that is subject to the Bayh-Dole Act. The next obligation, which helps the government protect its licensing right, is to execute or have executed and promptly deliver to the federal government all instruments that it needs to exercise its rights, whether it's a license, which is the standard thing that the government gets, or in some instances, the government can actually get a title. It can get title to the invention rather than just a license, and we'll talk about that in a little bit too. As I'm sure you were thinking to yourself after you saw that first requirement about disclosing subject inventions, you're going to need some framework in place to make sure that you can actually have that disclosure happen in a timely manner. And so the regulations, it's actually the standard clause itself, spells this out for you in detail. It says that you're required by agreement, or you have to require by written agreement your employees to disclose promptly in writing the subject inventions as they become aware of them. And then they also have to agree to assign the non-federal entity their rights and title in anything that they come up with in those inventions. And again, the purpose of this is just to ensure that the proper entity under the Bayh-Dole Act gets the rights that it's supposed to get. Similarly, at least 60 days before the statutory deadline, an entity must provide notice for each subject invention of any decision not to continue prosecution of a patent application. Again, it's to ensure that if, for whatever reason, a non-federal entity chooses not to pursue its rights in a subject invention, the government can pursue those rights and pursue a patent application instead. Continuing on, there are three more examples that I wanted to give of obligations to protect the government's rights. Another one is to include in specifications in a patent application a statement basically saying this invention is subject to certain rights that the government has. Frankly, the literature I've read suggests that this is a frequently ignored obligation, but again, a good compliant program will ensure that that statement is in there, and it's to help the government defend its rights when people are reading patent applications. There's also a requirement to flow down the standard Bayh-Dole clause into all subcontracts, regardless of tier, for experimental, developmental, or research work. That general requirement is just for small business subcontractors or domestic nonprofit subcontractors. But as we'll see in the next few slides, the government can tailor the Bayh-Dole clause in your agreement such that you have to flow it down to all subcontractors, not just small businesses and nonprofits. Finally, there are periodic reporting requirements, no more frequent than annually, on the utilization of subject inventions. And these reporting requirements really have to do with making sure that the subject invention is being commercialized, which is consistent with the goals of the Bayh-Dole Act itself. The regulations say that these reports should, to the extent possible, not be beyond what the non-federal entity already uses in its own documentation processes, and that it should comply with the Paperwork Reduction Act. So the goal is not to be burdensome. It's really about ensuring that the government sees or is able to see whether or not things are going as they should go. All right, so the next section covers how to protect your rights under this Bayh-Dole Act framework that we just discussed. And there are a lot of rules to follow, and there are a bunch of possible pitfalls where a non-federal entity can jeopardize or lose its patent rights that the Bayh-Dole Act otherwise grants them. And so I'm dividing this up into first discussing the potential limitations or even ways that you can lose that title right we talked about before in subject inventions. And then I'm going to talk about some steps that people can take to avoid those limitations and losses. So the first and sort of most fundamental one is that you can have a situation where there's an improper designation of an invention as a subject invention. And, you know, the drafters of the Bayh-Dole Act regulations foresaw this potential where there could be a disagreement between the government and a non-federal entity concerning whether or not an invention is a subject invention. And remember from before, the test is whether or not the invention was conceived or first actually reduced to practice in performance of a government project. So the regulations actually include some pretty helpful examples to assist people in knowing whether or not an invention is a subject invention. For example, if you're performing a non-government sponsored project, but it's closely related to a government-funded project, an invention that falls outside the planned and committed activities of the government-funded project is not a subject invention, and so it would not be subject to the Bayh-Dole Act or any of these requirements of the government's license. Another example of that is that inventions made outside of the research activities of a government-funded project would not be subject to inventions. And more specifically, and perhaps surprisingly to people, if you have an instrument that's purchased with government funds, but you later use that instrument to develop a new invention, and that use of that instrument does not interfere with or have any cost to the government-funded project that you're working on, then it's not a subject invention either. So it's really important to not just always think that just because government dollars were involved at some point along the process, everything is a subject invention and the Bayh-Dole Act is immediately implicated. You first need to do an analysis and figure out, is this a subject invention? And, you could have a situation where there's a disagreement with the government over that, and as we'll discuss later in the presentation, the Bayh-Dole Act and its implementing regulations anticipated such disagreements, and actually there are a number of appeals and disputes mechanisms that are available for those disagreements. The next potential way that a non-federal entity can lose its rights is the government has the authority to add provisions to funding agreements that actually require the licensing to the government or to other entities of non-subject inventions. So you could have a situation where you have an invention, everyone agrees that it's not subject to the Bayh-Dole Act itself. It was not developed with federal funds, but nonetheless, provisions could be added to your funding agreement saying that you have to license that non-subject invention to third parties. The reason why the government needs to have the authority to do that is there can be situations in which, for example, an invention that is a subject invention can't be effectively used or commercialized any other way. There is a process the government has to follow if it's going to add a provision like that to a contract. For example, an agency may not do this unless it's been approved by the agency head and there's a written justification that's been signed by the agency head, and has to conclude that the use of this non-subject invention by others is necessary for the practice of a subject invention or for the use of a work object of the funding agreement, and that such action is necessary. And so one term that comes up here is that it has to be necessary to achieve practical application of the subject invention. That's a key term of art in the Bayh-Dole Act and its regulations. It means to manufacture in the case of a composition of a product, or to practice in the case of a process or method under such conditions that establish that the invention is being utilized and its benefits are, to the extent permitted, available to the public on reasonable terms. That's sort of the key element, is that the invention is being used such that its benefits are available to the public on reasonable terms. And so if there's a subject invention and the government determines that there is not practical application of it, and the only way to get practical application of that subject invention is through the licensing of a related non-subject invention, you could have a situation where a provision is added to your funding agreement for that purpose. All right, so this slide I think is probably the most important one in the presentation, because this is the real key here. You can forfeit or lose title in a subject invention through inaction. And in particular, if you don't follow the Bayh-Dole Act's disclosure and election and patent application filing deadlines, then you can lose title and even a remaining license in your subject invention. So let's break that down a little bit. The regulations say that a non-federal entity will convey to the federal agency upon written request title to any subject invention if the non-federal entity fails to disclose or elect title to the subject invention within the time specified under the regulations. So that's why I put in red text a few slides ago that 2-month deadline for disclosing a subject invention to the federal agency. A failure to make that disclosure, as you see here, will result in you losing your title to that subject invention. So very important to make sure to have a process in place to ensure that that disclosure happens and that it happens in a timely manner. And similarly, if you don't follow the deadlines, which we'll get to later, for electing title or for filing a patent application, which both have separate deadlines, that can also result in this loss in title that we talked about. Finally, the middle one, you can also just elect not to retain title, and then the government has the right to request that you give that title to them instead. That one is less of a concern because the non-federal entity has determined for one reason or another that it does not want to seek to retain title. But the bigger concern is that you might have a subject invention that you want to keep title to, and you can lose that just by inaction. So that's the important thing to keep in mind here. So the next potential limit or loss of title in a subject invention that I want to talk about is that in those situations that we just discussed where the government can obtain title to a subject invention through one method or another, the grant recipient or the contractor that actually develops the subject invention still keeps a license in it. That's the default rule. And so it's sort of like a fallback where, you might lose by accident through inaction your title to a subject invention, but you still maintain a license to it. But it's important to note that even that license can potentially be revoked or modified by the government under the implementing regulations. And there are specific circumstances where that can happen. That term practical application is one of those examples. For instance, where the government might say, we don't really think that there's practical application happening here because of your license. We're going to modify or revoke that remaining license to you unless we see practical application. And as I put in the second bullet point here, there are some protections for grant recipients and contractors before the government actually has such a revocation or modification and implements it. The next example that I wanted to discuss is that standard Bayh-Dole Act clause that gets put into funding agreements can actually be subjected to alternative provisions that can be added into the contract instead. So there are multiple examples. I'm not going to run through all of them. They're in the regulations, and I cite to the portions of the regulations here so you can find them. But one example is that in exceptional circumstances, when it's determined by the agency that restriction or elimination of the right to retain title to any subject invention will better promote the policy and objectives of the Bayh-Dole Act, then the government can put in an alternative provision that does not permit retaining title to that subject invention. As you saw early on when Spencer was talking, the policy goals of the Bayh-Dole Act are pretty broad. And so you could conceivably see a situation where there's a disagreement between a grant recipient or a contractor and the government concerning whether or not the policy goals really require that entity to give up its title to a subject invention. And so that can be another area of dispute. And for that reason, the regulations also state that the agency has to provide the grant recipient or contractor with an opportunity to receive greater rights if that non-federal entity later shows that they have a plan to bring the subject invention to practical application. And those are called deferred determinations proceedings. As I mentioned before, in addition to alternative provisions to the standard clause, the regulations also permit certain more minor modifications and tailorings to the clause, and those are more specific. I won't discuss every example here either, but three ones are, as I mentioned before, rather than just having the flow down of the Bayh-Dole clause be to subcontractors that are small businesses and nonprofits, the contracting officer or the grant officer can decide to have the flow down go to all subcontractors. Similarly, the government can also incorporate other applicable government-wide regulations on patents. And there are also ways to unilaterally call for future amendments to the funding agreement so that the government can meet its own treaty obligations. And that clause is really about the fact that there might be future treaties that involve intellectual property, and it's an acknowledgement that the government, in order to comply with those treaties, might have to amend the funding agreement. So next, this is sort of a hot button topic that Spencer's going to discuss later on in the presentation a little bit more, but it is called the government's exercise of its march-in rights. And the idea is that the government can, quote unquote, march in and require a non-federal entity to grant a license to a third party to use a subject invention. There are limits, there are specific circumstances where this can happen. It can be on the basis of practical application, health or safety, public use, or preferences to United States industry. Those are spelled out in a little bit more detail in the regulations. As Spencer will talk about a little bit later on, there have been calls in recent years for the government to use its march-in rights to try to lower the cost of pharmaceuticals. So far, the government has not elected to do that and has not interpreted the Bayh-Dole Act as really being the proper vehicle for solving that particular policy issue. But nonetheless, the march-in rights granted by the Bayh-Dole Act could be significant if they were exercised. On this slide, there are some specific limitations that are related to nonprofits that I wanted to run through quickly. The first is that a subject invention can't be assigned by a nonprofit unless there's approval from the federal agency, with certain exceptions. One exception is that you can assign it to an organization which has as one of its primary functions the management of inventions. A common example might be a foundation that a university sets up for that purpose. Nonprofit NFEs or nonprofit non-federal entities must also make efforts that are reasonable under the circumstances to attract licensees for subject inventions that are small businesses. And under certain circumstances, they also have to give preference to a small business firm when licensing a subject invention. The regulations have a lot more detail on that. The government can get involved in certain circumstances, but when the government does get involved in that small business preference, it's really more of an evaluation of the nonprofit's program for small business involvement rather than getting involved in individual decisions about a particular small business and its complaints about whether or not a nonprofit entity is effectively giving any preference to small businesses when it's licensing its subject inventions. That said, individual small businesses are permitted under the Bayh-Dole Act regulations to submit a complaint to the funding agency concerning a given nonprofit's program for small business preference. And then finally, I wanted to highlight some royalty restrictions that apply to nonprofits. In particular, nonprofits have to share royalties collected on the subject invention with the inventor. And this is actually a pretty important and significant change that the Bayh-Dole Act brought into play, because it does arguably shift the monetary incentives for inventors working in academic institutions, at least arguably. And the other thing to understand about royalties or income earned by a nonprofit with respect to subject inventions is that after payment of expenses incidental to the administration of that invention, the nonprofit has to ensure that those royalties or income are used to support scientific research or education. All right, there's also another limitation on that entire right, title, and interest in subject inventions, which is the United States domestic preference. This comes into play in the standard Bayh-Dole Act clause that's in the funding agreement. Basically, the idea is that if you want to grant an exclusive license to someone in the United States, they're the only one in the United States who has a license to this invention, they also should have to assure you that they will be manufacturing it they'll be doing manufacturing related to the invention substantially in the United States. Sorry, a reminder just went off for me to say that for those of you who are seeking CLE credit in either California or New York, the CLE passcode or word is technology. Again, the CLE word is technology. All right, getting back to the presentation here, in terms of this United States domestic manufacturing preference, it can be waived by the federal agency, and this is actually something that can be a subject of dispute and appeal, as we'll discuss later on, if certain requirements are met, and that standard is stated on the slide here. Okay, so that was a lot. Clearly, when the Bayh-Dole Act says entire right, title, and interest, it is a significant right that's been granted compared to what was available prior to 1980, but there are also a lot of limitations to consider and obligations to ensure that you comply with. So, you know, what steps can you take to avoid these limitations or losses of an organization's patent rights and subject inventions? So, you know, the first recommendation is to really make sure that you have a system in place to comply with the standard clause. Scrutinize those terms, make sure that to the extent that your clause in your funding agreement deviates from the standard clause in any way, you account for that in whatever systems you have in place, and really give a lot of focus to the obligations in the standard clause that are there to protect the government's rights in particular, because those tend to be the ones that the Bayh-Dole Act has the biggest consequences for if you don't comply with them. As we said before, if you don't timely disclose the subject invention within 2 months, then it can be very costly because it results in a loss of not just title, but also your licensing rights that might remain even after losing a title to a subject invention. Similarly, you have to elect to retain title within 2 years of disclosure of that subject invention to the federal agency. And the agency can actually shorten that election notification period to a date that is no more than 60 days prior to the end of the 1-year statutory period. And that period is the period wherein a valid patent protection can still be obtained in the United States. So let's break that down a little bit because it's complicated. Basically, the default rule is you have 2 years after disclosure of the subject invention to elect title, but the agency can shorten that period of time such that, you know, you really only have up until the government needs to make sure it has enough time to get a patent instead of you if they are going to get title. So it's important for that reason.
Quick, Chris, your audio is breaking up a little bit. If you can, might be too close to your microphone.
Oh, okay, I'm sorry. Does it sound better now?
Yeah, that seems to be a little better. Thank you.
Okay, it might honestly be the call itself because you sound choppy to me now too. All right, hopefully people can hear me okay. Okay. So yeah, to reiterate that point again, generally you get 2 years after you disclose the subject invention to tell the government whether or not you're going to be electing to keep title to it, but the government can shorten that down and all the way down to making sure that that 1-year statutory period for actually getting a patent application, the government needs to have at least 60 days before that year-long period expires. It used to be 30 days, so grant recipients used to have a little bit longer to make the election with the government, but now it's 60 days. All right. So the next recommendation for preserving patent rights is to timely file your patent application or risk losing title. So this is similar to the prior two deadlines. One is the disclosure of the invention, and 2 is the election. Now it's the actual patent application itself. The general rule is that it's within 1 year after election, as I said before. But if the non-federal entity files a provisional patent application as its initial patent application, which has become more common, then you have to file a non-provisional application within 10 months of that provisional one. And there are certain other timeliness requirements to consider for international patent offices in other countries. Those are spelled out in more detail in the regulations. It's important to note that an agency can grant an extension of the time for filing, but it's at the agency's discretion. So, that's something to keep in mind if you're coming up close to a deadline, is to maybe try to work with the government to see if you can get an extension. Another thing that I like to mention regarding the preservation of rights is that you should really try to apply confidential markings to protect your proprietary information with the government. As I said before, there are reporting requirements that come with the Bayh-Dole Act and having patents in subject inventions. And the Bayh-Dole Act regulations and the Uniform Guidance both have specific requirements for the government to follow in terms of how it's disclosing or releasing information and documents to the public under the Freedom of Information Act, for example. But nonetheless, the regulations still say that non-federal entities will continue to provide confidential markings to help prevent inadvertent release outside the agency. So that's just a good practice to make sure that you always mark anything as confidential or proprietary to the extent you can. It's also really helpful to know when you can dispute an adverse determination that the government has made regarding your rights in a subject invention. And the Bayh-Dole Act regulations, kind of scattered across them, have a lot of different places where they specifically give a non-federal entity the rights to dispute a determination by the government and then make an appeal. And so these next couple slides pull together those different areas, and they reflect all the vast majority of the different segments that I discussed before where a non-federal entity can lose their rights. So, for example, we mentioned before that you could have a disagreement with the government about whether or not an invention is actually a subject invention. That's something that there is an ability to dispute and or appeal with the government. Similarly, a determination by the government that march-in is appropriate. There are actually very detailed regulations about how that process is supposed to go. The government actually has an obligation to alert the non-federal entity before it is going to exercise its march-in rights and provide that entity with an opportunity to give feedback on whether or not march-in is truly appropriate. But even if that doesn't work out, there's a chance to dispute that determination. Similarly, if the government determines that an alternative provision to the standard clause should be used, that's another area where dispute or appeal can happen. Or if the government determines that it's not going to grant an extension of time for disclosing a subject invention, electing title, or filing a patent application, that's something else that can be disputed as well. On the next slide here are another few examples of where you can have disputes or appeals. One is where the government's determined that a non-federal entity should convey title in a subject invention to an agency. Another example is where the government has determined that it's going to not waive that U.S. domestic manufacturing preference that I discussed before. Similarly, if the government denies a request by a nonprofit entity to assign its patent rights, remember we said before that nonprofits have that extra requirement where they're not allowed to assign patent rights unless it's to a particular kind of entity without the government's prior permission. If the government withholds that permission, that's something that you can dispute or appeal. Similarly, we mentioned before that if you lose title in a subject invention, the default rule is that you still retain a license in it, but the government can revoke or modify that license. That's another determination that you can dispute or appeal. Finally, I mentioned deferred determination proceedings before. That was in the case of the government putting a restrictive clause in the funding agreement, but still allowing for the non-federal entity to get those rights back later on if they presented a plan to enhance practical application of the subject invention. If that request for greater rights through that deferred determination process is denied, that can also be disputed or appealed. So that covers the overall picture of the Bayh-Dole Act, how it works, and how non-federal entities can take effective steps to defend their rights under the Bayh-Dole Act to make sure that they don't inadvertently lose title to their subject inventions. With that, I was going to turn it back over to Spencer again to talk about some kind of current affairs going on with the Bayh-Dole Act.
Great. Thanks, Chris. So in its 40 years, there have been a number of critiques of the Act, but for these purposes, we're just going to focus on two areas that are closely related. One is allegations that universities have become like intellectual property like hoarders and patent trolls, things like that. Others, another area that we'll touch on is, Chris alluded to it earlier, is people or entities petitioning NIH to assert its march-in rights in order to like control drug prices and reduce the cost of them. So on the allegations of intellectual property hoarding, if you just Google universities and patent trolls, you'll see a number of articles and incidences of universities going after alleged patent infringers. And in other instances, what it is those technology transfer offices that I mentioned earlier. They will partner with the patent assertion entities, which are also known as patent trolls, and partner in that, like, they just, as soon as they get anything patented, they license it over to them, and then the patent trolls, they go and do their thing. So it's received a lot of attention, and mostly the universities and other research institutions have gotten together and produced this document called the 9 Points to Consider in Licensing Technology. So originally it was 11 drafters, which has since expanded. There's well over 100 signatories to this agreement. And so as you'll see in the slide, there are a number of points that directly speak to this, such as point 6, like enforcement action should be carefully considered. Point 8, be mindful of the implications of working with patent aggregators. That's one area of criticism that the entities have been responding to on their own. But another area, and this is one that's excuse me, received a lot of attention, and we think will continue to see a lot of attention, is using the government's march-in rights to come in, ignore the exclusivity of patent holder, and begin licensing it to reasonable applicants. And it's been proposed in a 2016 letter that several members of Congress sent to Secretary of Health and Human Services and the Director of the National Institute of Health, urging the administration to exert its march-in rights in response to a specific drug in order to bring down the cost of the drug. The idea being that they would issue licenses to generic manufacturers. But the response has generally been that there are certain triggers, statutory triggers, that authorize the government to come in and exercise its march-in rights. But lowering the price of pharmaceuticals does not satisfy any of those statutory triggers. Here are those triggers. So, as you see in red text, action is necessary to alleviate health or safety needs. this is the provision that is most frequently cited in these petitions. Then it's also backing up, and it's 40 years. NIH is the only federal agency that we're aware of that has received these petitions. And again, the petitions it's from like a third party requesting the government exercises march-in rights over a certain drug, the underlying patent, which led to commercialization of that drug, was funded through, federal dollars. So people say that there's this drug that treats a condition, but the drug is too expensive. Therefore, to alleviate the health or safety needs of people suffering from this condition, the government needs to come in, exercise its march-in rights, and issue a license to a third party. NIH has denied every petition. In a 2004 petition response, NIH specifically responded to this point on the issue of using its march-in rights to lower drug prices. As you can see, it's pretty clear that NIH views this as an interpretation issue and strongly disagrees with the idea that it can exercise march-in rights to lower the cost of drugs. And at the very end there, you see the issue of drug pricing has global implications and thus is appropriately left for Congress to address legislatively. That said, recently, and circling back to a point is made at the start, COVID-19 is having very far-reaching effects on everything, and Bayh-Dole is also implicated by that. The Congressional Research Service, which is the research arm for Congress, put out a report on potential countermeasures to COVID-19. One excerpt from it noted that, as you see here in the quoted text, in the context of a pandemic like COVID-19, the health or safety needs language would appear to provide a possible basis for the exercise of march-in rights. So again, the government's not saying that march-in rights can be exercised at lower prices. Rather, here it's in response to a pandemic. But this demonstrates that there is a continued interest and focus on the Bayh-Dole Act. We've had recent presidential candidates come in and say like they would tell their administration to exercise march-in rights to respond to drug prices. But again, this is something that we'll see what happens and continue to monitor. And with that, I'll leave it back to Liz and Chris. If you guys have anything.
Yeah, Spencer and Chris, thank you so much. And I know we're experiencing some pretty significant audio difficulties, and for that, we apologize. We do have a few minutes for questions if people want to log those in. We'll take a look, and some of those we'll try to answer. Some of them we may not be able to answer. I know one of them asked for a percentage of small businesses that have been negatively impacted by the Bayh-Dole Act. I'm not sure if we have data on small businesses versus others that might have been impacted by that act. But I'd like to kind of put a question back to my two panelists, Chris and Spencer, and certainly you guys can figure out who's best to answer. But can one of you tell us what happens when you challenge one of these exception clauses that are being added to the contract? In other words, what is the ramifications to the contractor or the grant recipient?
I can answer that, Diz. This is Chris again. So the question is about there are situations where the government can add these alternative provisions into the standard Bayh-Dole clause that limit your rights that the standard clause otherwise would not do. And so, the question might arise, well, if we want to challenge that while we're negotiating the terms of the funding agreement, what happens? Does everything go on hold, or do things kind of proceed as they would ordinarily with this one thing still up in the air? And the regulations do provide an answer for this. They say that if the non-federal entity asserts a claim saying that, we disagree with this provision being added to the funding agreement, that claim cannot be used as a basis for withholding or delaying the award of a funding agreement or for suspending performance under an award. So, just because you raise your hand and say, I don't disagree with this, doesn't mean that the government on that basis alone can withhold or delay the award of the funding agreement or suspend performance under the award. But the regulations do go on to say, though, that pending final resolution of that claim, the contract can be issued with the patent rights provision proposed by the agency. So in the interim, while there is still a disagreement about that provision, it goes into the funding agreement sort of on a temporary basis, but that it's in there until there's final resolution. But if the final decision by the agency is in favor of the non-federal entity, then the funding agreement will be amended, and the amendment will be made retroactive to the effective date of the funding agreement. So that's sort of how it gets handled in terms of negotiating the terms of the funding agreement on the front end, and there's a disagreement about whether or not a deviation from the standard Bayh-Dole clause is appropriate.
Thanks, Chris. Another question came in, and I'll give it my thoughts, and then Chris or Spencer, if you have anything to add, please feel free. But one of our participants said there's a multi-agency effort led by NIST to amend Bayh-Dole, and Stevenson Wilder. They're asking for a summary of the legislative and regulatory proposals for these amendments. Unfortunately, we can't really get into probably summarizing concerns, that the government has vis-a-vis industry on this. I think, as Spencer noted at the very beginning, what was found was that the government had significant intellectual property tied up without making use of it. And so the Bayh-Dole Act came about. And so the issue then is, has the pendulum swung too far to where now private industry is developing intellectual property, for private use with taxpayer dollars? And I think the issue is there somewhere in the middle that folks can kind of land on, where people are comfortable that this federal money is being used and that stuff is being made available to the public, not for necessarily commercialization. So we'll have to kind of keep an eye on how that goes. Candidly, I think it's something that is unlikely to get much traction in the current environment. I think there's really only one issue being discussed these days, but it is something that I think you would want to keep an eye on post-presidential election to see where things go. As Spencer mentioned, there were several candidates that were very emphatic about their views on Bayh-Dole and the use of government marching rights. And so I certainly think the next administration, whichever party it might be, especially based on the outcome of COVID-19, may have the views on how best to deal with intellectual property developed at government expense. So unfortunately, we can't get into a summary of that legislation right now, but did want to give some thoughts on that. I don't know if Spencer or Chris, if you had anything to add on that.
I don't, Diz. I saw another question came in that I was going to tackle, but if Spencer has something on this one first, he can go ahead.
That's all right. You go ahead, Chris.
Okay. So another question came in, and it asks, are we aware of any instances in which the government exercised its right to take title to a subject invention because the non-federal entity failed to timely disclose or elect to retain title? And then a follow-up question is, has the government done so in any cases where that non-federal entity was diligently working toward patenting and commercializing the subject invention? And I'm not aware of any particular examples that come to mind. But I do think that the question highlights a very important point, which is that the regulation is written in such a way that it says the NFE will transfer title to the government upon the government's request. The government does not, title doesn't automatically go to the government, and the government doesn't have to take title just because the non-federal entity fails to timely disclose or elect title or pursue its patent application with the USPTO or in some foreign jurisdiction. The government reserves the right to seek out and get that title if it wants to, but it doesn't have to. And so I think the question is really a good one, because it highlights that even if you're in a situation where you have not, for one reason or another, been able to timely disclose or elect title, for example, to a subject invention, it doesn't necessarily mean that the government is going to take title to it. And it may well be that there are good reasons that are worth discussing with the government to say that, notwithstanding the fact that the government could take title, it would be better for all parties involved if the non-federal entity pursued a patent application and retained title instead. And, it could be that if you presented a good plan to the government for moving forward, taking title and effectively commercializing the item in a way that the government doesn't have the capability of doing, that would make the most sense, notwithstanding the fact that a deadline was missed. So I think it's a really good question that that highlights that just because your rights could be lost or jeopardized by something doesn't mean that there aren't creative solutions to help remedy the situation.
Thank you, Chris. I think that wraps up the questions that we have received. I do want to thank both Chris and Spencer for their time today, and also all of you for joining us. I know there's a lot of things happening right now, so we appreciate you joining us. And I want to also flag that this is the first of a 4-part series this year. The Venable Government Contracts and Grants Group will be doing webinars on a quarterly basis. So this was the first, and obviously we'll have other webinars intermittently, but we'll certainly be doing them on a quarterly basis. So please keep an eye out for our future webinar topics. If you have any suggestions, we'd love to hear that as well. If you're not part of our mailing list, please reach out to our marketing team, and we will have you added to our mailing list going forward, so you can receive updates, both written updates as well as updates on future webinars. With that, I want to thank everyone for participating, and we'll go ahead and wrap it up.